So welcome to this discussion. Basically, we shall be looking at the preparation of the final exam of professional conduct and ethics. But let us first have a recap of what we covered in term one. Basically, we are dealing with the Advocates Act together with the Advocates Professional Conduct Regulations, and we had Regulations 2, which basically provide that no advocate shall act without instructions, and also Regulations 2, sub-regulations 2, which provide that an advocate must conduct proper due diligence. And in as far as that is concerned, we look at the case of one Chemaongezi Kamis and another versus Kapuchurwa Referral Hospital. In that case, what happened was that council had sued a hospital, but then there was a PO that had sued a wrong party, and they said that the hospital was under the local government, the Kapuchurwa local government, so it was the proper party to be sued. So the case was dismissed, but of course the court condemned the advocate for failure to do adequate due diligence to establish which proper party was to be sued. So basically that was a professional misconduct. Then also the case of Peter Jagotabu and versus the judicial trustees of the Church of the Province of Uganda. That case is Lucas Crascus as far as instructions are concerned. The court is the effect that you cannot act for a client without instruction. So in that very case, the court was faced with the issue of whether there was an advocate-client relationship. The advocate was providing services to the church, but in light of the church for them they sold, he was just a chancellor. So he was just giving odd advice as an odd man of the clan. So basically this was a diocese, and after then there was a disagreement as whether he should be paid advocate's fees or he was just entitled to the allowances. So the issue before court was whether there was an advocate client relationship, but of course court was reluctant to find that there was one, in light of the fact that there was no letter of instructions to prove the same. The advocate alleged that had been stolen, and of course the court was reluctant to find the same, but it said still, however, the advocate was entitled to recover some costs for the services he had rendered. So basically that's regulations 2 of the Advocates Professional Conduct Regulations. Then we look at the withdrawal of cases. And Regulation 3, an advocate may withdraw from the conduct of a case on behalf of a client at any time. So when we look at Regulation 3, an advocate may withdraw from the instructions, or the client can withdraw from the instructions. So this basically means that you can only withdraw where the client says maybe instructs you to do a professional misconduct. So we have the case of course, Biencha Chika and Company versus Fang Min. That case, there was an agreement between the client and the advocates that, of course, after winning the case, they were going to be paid some sum of money. Then after that, after recovering the money, of course, there was a disagreement as whether she should pay that money or not. So, of course, because of that agreement, the client proceeded to withdraw instructions and then proceeded to instruct another law firm. So when instructed another law firm, now the other law firm claimed that Biencha and Cheka Company advocates were not entitled to the amount of money they were claiming because it was a Champati agreement. And of course the court agreed with them, but basically for this part we can see that Fang Min withdrew instructions to Biencha and Cheka, and also instructed a new fresh firm which now took over Biencha, and said that this agreement you had signed with our client now was a Champati agreement, and it was not also registered, so you cannot recover from this void transaction. And of course the court agreed with them. So we know that Champati agreements are the ones where you find that the advocates wants to enjoy the fruits of the judgment. That becomes now a Champati agreement because it's contrary to public policy. And we can see that in the case of Shell Uganda and others, was Fred Muema and Company advocates. Fred Muema had signed an agreement with all these other Shell, with other petroleum companies, including Rock. So they had an agreement that if he can help them recover taxes I think they are up to the tune of 64 millions. Then, of course, he proceeded and recovered, and then the issue was now whether they could reduce now, or he could be given the 8 billion that they had agreed that he would be paid. So after the judgment in the favor of the petroleum companies, now Rock tried to contact Shell that they should also be they should contribute to pay the advocate. Now Shell said, for me, I was not party to an agreement, but even if I was party still, this is a Champati agreement. Still, the advocate cannot benefit from it. So that's why we see Shell now suing Fred Mwema and saying now they had signed a Champati agreement with Rock, and even still we are not part of that agreement, so there is no way we can pay. So still the court found that there was a Champati agreement which the advocate was not entitled to deliver any benefits. So basically that was withdraw from cases under Regulation 3 of the Advocates Professional Conduct Regulations. Then we also looked at basically non-disclosure of clients information and Regulation 7, that you should not proceed and disclose the information of your client, and this should be read together with conflict of interest, that you should not act for your client where there is a conflict of interest. So Regulation 7 and Regulation 10, judicial duty relationship, should be read together. And on that case, we have, of course, Uganda versus Patricia Ojangore. In Uganda versus Patricia Ojangore, what we see is that Legal Mark had acted for UEDB to make a report which they had used to interdict Patricia Ojangore. But then when Patricia Ojangore was being prosecuted for corruption and embezzlement, now Legal Mark comes in and they wanted to defend Patricia Ojangore. Yet the employer UEDB, Uganda Electricity Distribution Board, had worked on the same report that was prepared by Legal Mark to fire or maybe to interdict this Patricia Ojangore. Of course, now the issue, you see Uganda objecting, saying that this was there was a conflict of interest, and of course the court agreed with them. So the case of Uganda versus Patricia Ojangore is the locus classicus case as far as conflict of interest is concerned, and the duty of the advocate not to basically release information to your client. Then also that was one of the cases we also looked at during our preparations. So I think basically that is it as far as most of these things are concerned. We also looked at that lawyers must have an account for the firm, and also the account for personal accounts under the advocates account rules. So basically that's what we looked at as far as term 1 was concerned. So you have to have a recap of that because they give you now where we're going to be heading to. But just today we're going to be looking at first and foremost, we shall look at judicial practice, and also what arises therein in judicial practice, because that was also been covered. But what is very, very important to understand is that we have the judicial oath, that once you have been appointed as a judicial officer, you have to swear an oath, and they are required to take a judicial oath and under Article 149, which is in the Constitution of the Republic of Uganda in the 4th schedule. So that oath, once you have been appointed as a judicial officer, you must first proceed and take a judicial oath in light of Article 149 and also the 4th schedule of the Constitution. Then from there we proceeded to look at ethical theories and principles of judicial conduct. Then after that, I wanted us to cover the Judicial Code of Conduct. So principles of Judicial Code of Conduct. So when we talk about Judicial Code of Conduct, first and foremost, we look at the principle of independence, impartiality, integrity, equality, and competence and diligence. Because these are for you to be a judicial officer, you must ensure that you first and foremost you are independent, you are impartial, and also integrity, equality, and competence. So independence and independent judiciary is indispensable with the proper administration of justice. The judicial officer therefore should uphold and exemplify the independence of the judiciary in its individual and institutional aspects. So basically, we can see that the judiciary is established as an independent body. So it basically means that even you as a judicial officer to perform your duties, you must be independent. Then impartiality is the essence of the judicial function and applies not only to the making of a decision but also the process by which the decision is made. So you must be impartial, and where you are not impartial, you must recuse yourself. And impartiality is the canon of Article 28 of the Constitution. Under Article 28 of the Constitution, there must be a fair hearing, and one of the canons of the fair hearing is that there must be impartiality. Then integrity is essential to the proper discharge of the judicial officer. The behavior and conduct of the judicial officer must reaffirm the people's of faith in the integrity of the judiciary. So this goes back now to how do you act and how does the public perceive you. Then also that propriety and the appearance of propriety are essential to the performance of all the activities of the judicial officer. The judicial officer shall avoid impropriety and the appearance of impropriety in all judicial and personal activities. So a judicial officer shall at all times conduct himself or herself in a manner consistent with the dignity of the judicial office, and for that purpose must freely and willingly accept appropriate personal restrictions. Then the other one we looked at was equality. All persons must be treated equal, and of course we can see this in the Constitution, I think Article 22, which basically provides for equality before the law. And then competence and diligence. Judicial officers must be competent in all their activities, because that's basically why we have the Judicial Institute, which is responsible for imparting skills to judicial officers. Promotion and enforcement. The Judicial Integrity Committee, peer committees, and many other institutions, the judiciary as a whole shall promote awareness of the principles and rules set out in this code and shall encourage all judicial officers to comply with them. So basically, those were the principles of judicial conduct in court. We looked at independence, we looked at impartiality, integrity, equality, competence, and diligence as the principles of judicial conduct in court. So from there, we proceeded. From there, we can now go to look at recusal of judicial officers, the constitutional recusal of judicial practices, 2019. The backbone of constitutional recusal of judicial officers practice the elections 2019 in Uganda is the need to preserve the independence, impartiality, and integrity of the judiciary. So we have looked at recusal under paragraph 4 of the Constitution. Recusal of judicial officers practice the election 2019 to mean the act of abstaining from participating in an official action in which his or her impartiality would reasonably be in question. So where in fact you see that you have an interest in the matter, as a judicial officer you must proceed to recuse yourself from that matter. Circumstances under which judicial officer may recuse himself or herself. Paragraph 6 provides for the circumstances, and they are: 1. Where the impartiality of the judicial officer may reasonably be questioned, where the judicial officer has personal knowledge of the disputed facts concerning the proceedings. 3. Where a member of the judicial officer's family is representing a litigant, is a party, or has an interest in the outcome of the matter in dispute. So basically, paragraph 6 gives you situations where the court will think that there is an interest that you must recuse yourself. And one, we see where the impartiality of the judicial officer may reasonably be questioned. Assume, for example, you are in a body, and then that body has come to litigate. For example, you belong to a certain group, and that certain group is the one who are the litigants. Then where the judicial officer has personal knowledge of the disputed facts concerning the proceedings. So where you have knowledge of the facts also, you must recuse yourself. And where a member of the judicial officer's family is representing a litigant. So duty of the judicial officer upon recusal, paragraph 6.3a provides for what must be done by a judicial officer after he or she recuses themselves from a matter. The judicial officer must notify the parties, and the matter shall be allocated to another judicial officer, and the judicial officer shall state on record the reason for recusal. Recusal are the instance of parties Regulation 7 provides for circumstances and which parties may apply to court for a judicial officer to recuse himself. One, where a judicial officer has an interest in the subject matter. Two, where a judicial officer has background information or experience. Three, where a judicial officer has personal knowledge about the parties. Four, where a judicial officer has ex parte communication with lawyers. Five, where a judicial officer makes inappropriate comments. And six, where a judicial officer has exhibited actual, imputed, or apparent bias. So basically, under paragraph 7, we can see under what circumstances can a party apply to court for a judicial officer to recuse himself. And they are saying that one, where a judicial officer has interest in the subject matter. Two, where a judicial officer has background information or experience with the lawyer. Where judicial officer has personal knowledge about the parties, and where judicial officer has ex parte communication with the lawyers, or where judicial officer makes inappropriate comments. So procedure for recusal: a party who seeks the recusal of a judicial officer may do so by letter, copied to all parties at the register of the court, orally in open court in the presence of the parties, and the judicial officer against whom recusal is sought shall be given an opportunity to respond at the concerns. So topic 8, judicial misconduct. Judicial misconduct occurs when a judiciary officer acts in a manner that is considered unethical. So basically, this is where we have the Judicial Service Commission, because remember, the Judicial Service Commission is established to appoint and discipline judicial officers, and it's established by the Constitution. So in Uganda, legal and ethical standards of judicial officers are instituted in a couple of laws and statutes, to which the Judicial Service Act, the Judicial Service Commission Regulations, and the Anti-Corruption Act, as well as the Uganda Code of Judicial Conduct. So the offenses under the Judicial Service Commission Regulations include favoritism, nepotism, corruption, discrimination, engaging in private interests, contravening any provisions of the law. Then also have offenses under the Anti-Corruption Act, like the way we discussed, to include abuse of office, sectarianism, bribery, corruption, among others. Then from there, we have to look also at judicial discipline and misconduct. Basically, Article 146 establishes the Judicial Service Commission. The functions are under Article 147 of the Constitution, which provides for the function of the Judicial Service Commission to advise the President in the exercise of the powers to appoint judicial officers, to receive and process people's recommendations and complaints, to act as a link between the people and the judiciary, and to advise the government on improving on the administration of justice. Remember, we also have the Administration of Justice Act. Then Article 147 of the Constitution. The Commission is charged with exercising disciplinary control over judicial officers, receiving and processing public recommendations and complaints. So Judicial Service Complaint and Disciplinary Proceedings Regulations of 2005 under Section 25 of the Judicial Service Act. The Judicial Service, we have the Judicial Service, which was established, and then we have the case, many cases, Agwebire versus Attorney General, the High Court decision refusing judicial review of the decision, leading to his interdiction while grade 1 magistrate at Nabweru. He had received, I think he was being interdicted of corruption. Also have other cases like Kawes Godfrey versus Attorney General. But basically, where there is an offense, for example, where the judicial officer receives a bribe, then you can be taken to the Judicial Service Commission for disciplinary mechanisms. Then we look at natural justice and the rule of bias. Of course, under Article 28 of the Constitution provides for a fair hearing, and basically which has been established in a lot of cases. For example, have the case of Ridge versus Baldwin. In the Ridge versus Baldwin, we had a police officer who was dismissed, and of course he sued, saying that the same body had also tried him. So basically, they were saying that there was no impartiality, there was no the body was not being neutral, and therefore there was no what we call natural justice. So natural justice must be done but also it must be seen to be done. So from there, we shall look at the tenure of judicial officers under Article, of course, 144 of the Constitution's High Court judges 70 years. Article 128(7), the studies, allowances, or privileges shall not be valued to his or her disadvantage. So you have to understand that the judiciary is established as an independent body by the Constitution. Removal of judicial officers under Article 144 for professional misconduct or maybe misbehavior, the judicial officer can be removed. And we have the Judicial Service Commission, which is bound to investigate the complaint by itself or by anyone authorized. So all the matters of the judicial officers are always handled by the Judicial Service Commission. Then enforcement of the Code of Conduct. We have the internal controls, Judicial Integrity Committee, peer committees, inspectorate of courts. Basically, all these ones are internal controls. We have looked at the Judiciary Integrity Committee, the peer committees, and the inspectorates of courts. Then disciplinary committee, the Judiciary International Disciplinary Committee, the Judiciary Internal Disciplinary Committee. There is also a Judiciary Disciplinary Committee established by the Chief Justice with power given to him by Article 133 of the Constitution to issue orders and directions to the courts necessary for the proper and efficient administration of justice. Then also have the IGG and DPP who also play those roles. Revisions questions discuss the criteria of disciplining a judicial officer from the time he commits an offense until punishment. So basically, I have to look at the Judicial Service Commission. You also have to look at the Anti-Corruption Act, the roles of the IGG, and then the DPP. What are the different institutions and their mandate towards arrest, disciplinary, and dismissal of the judicial officers? The same thing. Distinguish between disciplinary procedures for judges from that of other judicial officers. Remember, even lawyers are judicial officers. So basically, here we'll have to look at the disciplinary committee and the Advocates Act, as well as the Judicial Service Commission. What are the challenges of disciplining judicial officers? Of course, the challenges are very many. One, we have first and foremost, you have to understand that most of the crimes are online, so you find that there's no enough proof to prove those assertions. Then also there is also bias and misaccusations, among others. So discuss the administration of judiciary of Act 2020 on the independence and of the judiciary and administration of justice in Uganda. You now have the administration of judiciary Act 2020, which was basically established for the administration of the judicial officers, which provides for retirement packages for judicial officers, their independence, among others. Topic 9, a judge as a public servant and post-judicial life. What is public service? Article 175 defines public officer as any person holding or acting in an office in the public service. We also have Article 2572A gives examples: judges and magistrates, police officers, prison service, education service, and also health service. Section 2 of the Public Services Act. Public service is comprised of all persons duly appointed by the appropriate service commissions. Governing law, the Constitution, the Code of Conduct, the Uganda Public Service Standing Orders, as well as Public Services Commission regulations. Code of Conduct: accountability, decency, diligency, discipline, effectiveness, efficiency, impartiality, integrity, loyalty, professionalism, selflessness, transparency, public service standing orders. So basically, that's what we have called judicial officers as public servants, and we can see they are governed by the constitutions as well as the public service commissions regulations. Then customer care, judiciary as a service center, expectation of you as a public officer, judiciary client charter. The Judiciary Client Charter presents the commitments for the judiciary as mandated by the Constitution. Section 1 covers the judiciary vision, mission, mandate, and core values. Section 2 covers key results area. Section 3 highlights service standards. Section 4 is for service is for service commitment. Section 5 covers rights as a court user. Section 6 covers the client's obligations. Section 7 covers accountability, and Section 8 sets out the feedback, complaints, and appeal mechanisms. So basically here we can see the Judiciary Client Charter is the one which covers customer care of the judiciary. Then topic 12, post-judicial life. Post-judicial life, we have the administration of the Judiciary Act, which basically provides for benefits of the judicial officers, to include a furnished house, an annual medical allowance, a chauffeur-driven car, security provided by the state, retirement benefits for the Deputy Chief Justice, Section 22, emergency retirement benefit, benefits payable to retired justice of the Supreme Court, benefits payable to the justice of the Court of Appeal, benefits payable to the principal judge, benefits payable to the judge of the High Court. So you should get this administration of the Judiciary Act, because it provides for these things. The fact that it's open book, you have to be equipped. Disqualification from retirement benefits, Section 28 of the Judiciary Act, where the judicial officer is removed from the judicial service in accordance with the Constitution. That is for professional misconduct, where the judicial officer absconds from duty, you are also removed. Ways to prepare for retirement: 1. Savings, pension plan, investment. Don't touch your retirement savings. The art of judgment writing. Extract from present at the first magistrate conference at Collins Hotel. What's the judgment? I think it's just reasoning. It's just it provides the reasoning of court and the analysis of the lawyers, how the judge was able to come to that conclusion. What is expected of a good judgment? Communicated decision of court must be accompanied with reasons, must resolve the issues, must be final in the dispute before the court. Purpose of judgment: to determine the guilt or innocence of the accused person, settle matters, to provide accountability, to serve precedents, and to develop jurisprudence. Structure of judgments: judgment are constructed like other physical structures on paper. They have a foundation. Structure: heading, intro, body, conclusion. Contents: Section 8 of 20 TIA, Order 22 of the CPR must be written, English. Points of determination: decision, reasons, dated and signed. Findings of the fact, case law. Issues, questions, ingredients, burden of proof, beyond reasonable doubt, proof, applying the law to the facts. Evaluation of the evidence, language and style. So because this one deals on judgments and how you deliver judgments. Then we have the questions. Discuss the factors responsible for the decline of public confidence in the judiciary: perception and bias, efficiency or delayed justice, lack of transparency, corruption and judicial misconduct, inadequate accountability, politicization, enhanced transparency, among others. Discuss the criteria of disciplining a judicial officer from the time of committing an offense until punishment, interdiction. We have the Chief Justice report, the legal effect of commencing, procedure upon criminal conviction. What are the different institutions and their mandate towards arrest, discipline, and dismissal of judicial officers? The Uganda Police, Inspector of Courts, Inspector of Government, Director of Public Prosecutions, Judicial Service Commission, the High Court of Uganda, the President of Uganda. Distinguish between disciplinary procedures for the judges from that or other judicial officers, for example, magistrates. Grounds for removal, Article 144, who is a judicial officer, Article 144.7, who can remove the above judicial officers, the President. Procedure: what are the different institutions and their mandate towards arrest, discipline, and dismissal of judicial officers? We have the DPP, we have the Inspector of Government, among others. So basically that's analysis of professional conduct. As far as we have looked at professional conduct, Judicial Code of Conduct, and that's basically what we shall be looking at for our final exam. So let us just now look briefly at taxation. Let us briefly look at taxation. Yes, so welcome to tax practice. As far as tax practice is concerned, I saw in last year's exam there were objectives So first and foremost, introduction, tax law is rather a very specialized field of law. It is the most dynamic of fields of law. So the doctrine of judicial precedent is relevant, but the constant evolution of the law practice renders precedents of literal significance. So tax law is very unique on a country-by-country experience, such that reliance on authorities from other jurisdictions must be exercised with maximum care and scrutiny. So aims of the course is to develop ability to interpret the basic pieces of legislations for taxation in line with the applicable legal principles and correctly advise taxpayers. Course objectives to understand the tax policy in Uganda, develop the ability to object and file appeals against assessments by URA, and recognize and deal with issues relating to tax practice. What is tax? Tax has been defined as the imposition of compulsory duties for raising a revenue by the state. Tax has been defined as imposition of a compulsory duties for raising of a revenue by the state. So this simply implies that tax is compulsory on all the classes of persons it is imposed upon. Tax is imposed by the state through an act of parliament under Article 152, sub-article 1 of the Constitution of the Republic of Uganda. It provides that no tax shall be imposed except under the authority of an act of parliament. So basically you can see that this one helps us to understand tax, and we can see that tax is a compulsory imposition levied on all citizens of the country to collect revenue, and it must be imposed under the act of parliament, like the way we can see under Article 152 of the Constitution. Then tax is a two-stage process: the pronouncement by an act of parliament through an enactment. Secondly, the enforcement by a body that has been mandated to collect and enforce. The body in Uganda is the Uganda Revenue Authority and the Uganda Revenue Authority Act. Under Section 3 of the URA Act, one of the key functions of the authority is to administer and give effect to the laws or the specified provisions of the law set out in the first schedule. So in Uganda, the URA basically is the one that collects taxes. What is tax policy? President Harriet Truman once said that he wanted to find a one-armed advisor. This was because when he asked his policy advisors, they always answered on the one hand, on the other hand. So in the term tax policy refers to the guidelines and principles established by sovereign government for the imposition and collection of taxes within its jurisdiction or tax subject. The term tax policy refers to the guidelines and principles established by sovereign government for the imposition and collection of taxes within its jurisdiction or tax subjects. So basically that's what we call a tax policy. Requirements of a good tax structure or canons of a good tax system. One must be equity. Equity deals with the distribution of the tax burden. The burden should be fair. That means everyone should be made to pay his or her fair share. That's what basically means by equity. 2, fiscal neutrality. The principle of fiscal neutrality may be expressed variously. Economic efficiency. Taxes should be chosen so as to minimize inferences with economic decisions. Then certainty. The tax system should permit fair and non-arbitrary administration and should be understandable to the taxpayers. Economy. Administration and the compliance costs should be as low as possible. Revenue adequacy. The law structure should ensure adequacy of revenue collected. So basically those were the what we called requirements of a good tax system or canons of a good tax system. To include equity, fiscal neutrality, certainty, economy, and revenue adequacy. Then from there we look at what is taxation, the role of taxation in national development, canons or principles of taxations, interpretation of tax statutes. We have the retro constructions. Intention of the legislator must be found in the words used by the legislature. Strict interpretations, words to be construed strictly. Contextual interpretation, meaning of a term is understood mischief rule, mischief sought to be remedied by the amendment, harmonious construction, when the different provisions of the Act are harmonized or recorded, principles of beneficial interpretation, construction more favorable to the assessee in case of any doubts, and the golden rule that words should be given the ordinary sense unless the word lead to some absurdity. Then liberal construction, adopt the rule of liberal construction so as to give the meaning to all parts of the statute, so as no one is affecting the other. Ejusdem generis, as a rule where a statute there are general words following particular and specific words. The general words must be confined to things of the same kind as those specified, although this is a rule of construction, must be applied with caution. So, and then casus omissus, matter which should have been but has not been provided by the statute cannot be supplied by the court. So basically, those are the rules of interpretation of the tax system. One, literal rule that the words must be given their ordinary meaning. Then strict interpretations, words must be constructed strictly. Contextual interpretations, you must interpret a word as used in the sentence. Mischief rule, you must interpret the statute so as you solve a problem, or you by looking at the problem that the legislators wanted to solve. Harmonious construction, this deals with interpreting sections of the act so as they do not contradict each other. Principle of beneficial interpretations, constructions more favorable to the assessee in case of any doubt. So beneficial interpretation is that the statute must be favorable to the person. Golden rules, words should be given their ordinary sense. Literal constructions, adopt a rule of liberal construction so as to give meaning to all parts of the statute. Ejusdem generis, when in a statute there are general words following particular and specific words, the general words must be confined to things of the same kind. Casus omissus, matter which should have been but has not been provided by the statute cannot be supplied by the court. Overview of the taxation in Uganda. We have direct and indirect taxes. In Uganda, taxes are classified into direct and indirect taxes. The direct taxes imposed directly on taxpayers' income, and that person bears the burden of paying the tax directly. Whereas indirect taxes levied on consumption, for example, those ones you pay on matchboxes, on bread, those ones are indirect taxes. The ones on your income, direct taxes. Business income tax, other income tax. Business is defined as to include any trade, profession, vocation, or adventure. Business income means any income derived by a person carrying on a business, to include the amount of gains or losses from the disposal of business assets, any amount delivered by a person as consideration for accepting a restriction on the person's capacity to carry on business, the value of any gifts, interest delivered by a person, and rent delivered by a person. Trade has the same meaning as commerce and involves buying and selling or bartering of goods. There must be an element of profit, regularity of the transaction, and the arrangement and effort. Employment income under Section 19 of the Income Tax Act. Any income derived by an employee from any employment, whether past, present, or in future, including the value of any benefit and advantage. So basically, employment income is the one you pay on your job. Employment refers to position of an individual in employment, directorship of a company, position, holding, or acting in public service. Composition of employment income, Section 19. I think this was of the revised laws. Wages, salaries, leave pay, payment in lieu, the value of any benefits in kind, amount of private employment, terminal insurance premiums, payment, and discounts. So this all include employment income. Factors to consider when distinguishing between employer and contractors. We looked at these ones: the who controls the work, integration test, and also who has control over hours of work, who has control over allocation of place of work, who has control over sequence of work, among others. Property taxation, Section 20 of the Income Tax Act. Property income is defined to include the following: any dividends, interests, the value of any gifts derived, the amount of any contribution, and any other income derived by a person. Exempt income: certain incomes by law are not taxed and they are referred to as exempt income under section 21. So they include the following: source and residence principle of taxation in Uganda. So exempt income is the one which is not taxed, or which are exempted from taxation under section 21 of the Income Tax Act. For example, salaries of judicial officers. Chargeable income: section 15 of the Income Tax defines chargeable income for a year is the gross income, and also reduce the allowable deductions. So basically here you get the income of the year, then you reduce the deductions allowed by the law. Assessment and filing of returns under section 16 to 19. A tax return is the declaration form prescribed by the commissioner for a tax period of time. Income tax: every taxpayer is required to furnish a return of provision tax estimate. Value added tax: value added tax is tax on the value added on the goods. Pay as you earn or registered taxpayers are required to submit pay as you earn tax returns for each month by the 15th day of the following month. Structure of tax administration in Uganda: we have the departments of the URA to include legal service and board affairs, customs, domestic tax department, and corporate service department. With internal audit department, tax investigation department, and information technology. The two objects and appeals of the role of an advocate. So basically here we are looking at the role of an advocate, objections and appeals, and the role of the advocate. So you can object to the tax assessment by filing an objection. Also can appeal the decision of the tax appeals tribunal, as we can see in the case of Mera Investments versus URA. We have self-assessment, default assessment, advanced assessment, and additional assessment, and the different tax assessments. Then tax dispute resolution circles. We have one: a tax decision is made by URA to demand a specific sum of money. The taxpayer files an objection. An objection decision is made. ADR: tax appeals to the tax appeals tribunal, and then after that appeals to the High Court. Then also can appeal to the Court of Appeal and the Supreme Court. We can also have stay of execution or enforcement. You can apply for stay of execution. So basically that's a brief analysis of taxation. I saw they are being asked in objectives. It's better that you can look at them and try to understand them. You can never know what happens in the exam, but they are not hard things if you can read this document. So that's it we had for you. Please, we wish you success in your professional conduct and ethics exam.